Peace, peace, Barghani, Islam, Salam, Hetipu, Rahubat, Gino Lakum Ninani, Chief Noble Bandele Elamine, back again for another video. And today's video, we're going to be dealing with the power of ministers, okay? Whether you a minister or a pastor or a imam or a rabbi, whatever floats your boat. We're going to be talking basically about clergy or religious exemptions as the head of that religious organization. Okay, so that's what we want to get into today. But before we get into any of that, I'd like you to check out our links we have right here, the indigenous services .webs.com, and this is your one-stop shop for your Moorish, indigenous, or lawful needs. As you can tell, if you click on that site and if you hit links, if you tap on the links, it will show you a variety of different sources for law. The Public Library of Law, legal codes, state codes, it's got the federal rules of procedure, civil procedure, the federal rules of evidence, basically things that you'll need to know or that you may need at your fingertips. Social Security Act, we're in Ohio, so we got the Ohio Revised Codes, Declaration of Human Rights, all the different stuff. We got a vast array, a black law dictionary, pretty much anything you need, in a lot of case law. So please check out indigenousservices.webs.com for your one-stop shopping needs. Okay. Also, could you also please check out my books? You can find all of my books are on Amazon and they are affordable. Okay. So you can check them out. The top books is the Moorish Treatise. This is very important. My boy King El Bay been talking about treaties lately, and so it'd be really good for you to understand that. Moabite man, nationality, birthright, the other treaties, all that. So check me out. So with that being said, I want to get into the ministry, okay? Now, I use the term ministry. At the Temple of New Kemet, we consider ourselves ministers, but not in the typical sense of ministers when you deal with Christianity. We are ministers for the rites of passage. And so what we're going to do is we're going to look a little bit at the duties or the rights, privileges, whatnot of a minister, okay? It can be called minister, it can be clergy. So, we're going to look at like basics of clergy privilege, because one thing is, for whatever you are, any of the religious people, they have clergy privilege. So let us look at clergy privilege. It talks about in states that have it, clergy privilege, an ordained minister, priest, rabbi, or other leader of an established church or religious organization is required to testify in proceeding concerning anything that is pertinent said, which would be considered confidential in the religious leader's professional capacity, and when revealing such communication would violate a sacred or moral trust, and when the person making the confession objects to the revelation of such confession. So basically, this one is the popular one. I think a lot of people know about this, but basically this is saying that a minister or whatever religious leader is not required to testify in most cases against a member of that church who has, the key word is in confidential, something that would be considered confidential, okay, and that would break his sacred or moral trust. Because that's the wonderful thing about religion, is that it has its own jurisdiction. So it may make a sacred or vow to their religious God. Okay, and in our case, we make a pledge, to our ancestors. Some people might make a pledge to God or whatnot and they can't violate that. The state doesn't have jurisdiction to tell you to violate your vow to God. So it says, in this manner, a person may make a confession to a religious leader, and the religious leader should not testify against him or her about this confession. In this manner, a defendant can confess to a crime for pertinence while not taking responsibility for the crime in a criminal court of law. Okay, so this goes back to, like, a lot of times you'll see on TV or whatnot, but the Catholics do this a lot when they have confessions. So they go in there and say, I have sinned and whatnot, and the priest listens to the confession and they can't disclose that information. Okay, so that's kind of what the privilege is. The clergy privilege concerns confidential communication. These are private communications that are not intended to be disclosed to others unless necessary for the purpose of the communication. If the individual makes a confession in front of others, though, this would not be a private or confidential communication. So if you're talking about certain things in front of a congregation or more than anybody that's outside of the minister's eyes, and you're doing it in front of others, then that would not be considered confidential. Provincial of disclosure. It says, for states that have privilege in place, even if a clergy person wishes to disclose the communication, the defendant has the right to prevent the disclosure. So a lot of times in certain instances, if you've said something to a minister and the minister feels compelled by whatever reason to testify or say against you, you can object and probably motion that out of court. Okay, so let's look at this. Compelling disclosure. While the statute may permit the trial judge to compel disclosure of such confession if the trial court judges decides that the disclosure is necessary to properly administer justice. Other tests use balancing tests of sorts before deciding to disclose clergy privileged communication. The court may consider such factors that an act of safeguards against disclosing such communication. The communication in question must originate in a confidence, okay, which that they will not be disclosed, meaning that they are made under the relationship between the clergy person and the communicant. The communication is made with the exception of confidentiality, and that a breach of confidentiality will affect the relationship between the parties. If the communication is disclosed, the injury to the relationship will surpass the benefit gained in litigation. So there are loopholes in the disclosure agreement. Clergy initiated meetings, public confessions. Basically, a public confession would not be used. Now, another thing a minister can do is character witness. If a clergy person is called as a character witness in this case, clergy may be waiving the privilege and may be compelled to disclose confidential information. If the clergy person is asked to testify about the character of the communicant, then the information that he or she knows through confession or other confidential communications may be brought up. Okay, so that is part of what we're talking about. Okay, now, like I said, that kind of gives you a glimpse in the general understanding of it, but I want to get a little bit further into it. Now, let's see, is this the one? Let's go to this one first. Pastor, church, and law. I wanted to talk about this one now. Church law and tax. It says the authority, rights, and privileges. Okay. Now this one talks about, because the state is trying to clamp down on uh, the rights of ministers or religion. Okay, they're trying to clamp down on it in some instances, and so it says that the increasing secularism of our society has led to a sharp reduction in the number of legal privileges enjoyed by ministers. Nevertheless, some important privileges remain. So, for example, ministers are exempt from jury duty in some states. They are. Now this one is key. A minister is exempted by federal law from military service. Okay? Key. Ministers have the authority in all states. Now this is what I want to talk about. Okay? Because it talks about what ministers have the authority to do in all states to perform marriage, which is rites of passage, and confidential communications made to ministers acting in their professional capacity as spiritual advisors generally are protected against compelled disclosures in court of law. Okay, so a minister can act as a counselor, as many people know. You know, in many churches, especially in the melanated so-called black community, they are, you know, they don't tend to go to a psychiatrist, or they tend not to go to seek counseling from what you call academic people or whatever that's gotten their degrees. They would a lot of times go and get counseling from the minister, and the minister has the same client privilege as a psychiatrist, okay, or a doctor in this instance, which we'll get into. But it says that this last privilege is a very important one. It means, for example, that clergy ordinarily cannot be compelled to disclose in a court of law statements made to them in confidence during spiritual counseling, even if the statements include a confession of criminal activity. Okay, so once again, you cannot incriminate yourself under these clergy privilege. Okay. Now I want to go a little further. Let's go back to marriage. Okay, now we talk about, it says it can perform marriages. So with the fact that it didn't say this, but we all know that a minister can perform marriage ceremonies. It also can perform funeral rites. Okay, we know that. So any of those things in between. So for example, when we talk about rights to induct a child into adulthood, a right to administer who can be another minister, or who has the right to say someone is an elder. These things are also part of that as well. So when we talk about ministers' authority, with the temple, a new Kemet, the ministers have that authority to recognize these events and perform these events as ceremonies. Okay. So another important privilege is the exemption of pastoral counseling from laws prohibiting the unauthorized practice of psychology. So this goes back to what we were saying. A minister is exempt from having to say that he practiced psychology. As a minister, you can practice psychology without having a license or having gone to school, even though I have noticed that a lot of ministers have moved into psychology as a major along with their ministerial degree. But it says that these other privileges are discussed in detail later in this chapter. So there are other ones that we may get to. You should pay special attention to the condition that must exist for these privileges to apply. Okay, so it talks about, does a minister have the legal authority to sign documents on behalf of his church or preside at church meetings? Is the minister always the president? Now, these are things that need to be discussed, but for the purpose of the video, we're going to leave those questions, but they are important questions. What I wanted to focus really on was the fact of the power of the ministry, particularly dealing with members and their client privileges. Because at the same time, as Moors Americans, as indigenous people, African, Pan-Africanists, we do deal with court. We are subject to police, and more likely to have to go to court, and we're always looking for a way to be able to represent in court. So my thing is this: is a minister having the ability to actually be in court and speak on behalf of whoever is the defendant. And I say this because if you're going to have a ministry and you're a member of this ministry or you're a member of this temple, there may be certain agreements. And one of the things that me and King Obey discuss is the agreements. You'll sign a contract, and these agreements may mean that you cannot disclose information anyway, and that the only person who can disclose this information would be a minister. And so in our case, when we do these things, not just from the powers that we get from what we read in the state, but the fact that we contract and allow us to speak on your behalf. Okay? So I just wanted to go into that. Now, the other part of this, I wanted to look at again, deeper into the law. It talked about justices. So the justices rule ministers exempt from anti-bias laws. So what does that mean? It says that the U.S. Supreme Court, for the first time, check D. Let's see when this was. This was in 2012, okay? 2012 or so. The U.S. Supreme Court, for the first time, has declared that the Constitution exempts ministers from the nation's anti-discrimination law. Now, this is heavy. Wednesday's decision was unanimous and groundbreaking, but it left unresolved some of the thorniest questions in determining who is a minister and who is not. It says that court ruling in the case of Cheryl Parrish, a teacher at the Hosanna Tabor Lutheran Church and school in Michigan, okay, took leave when she was diagnosed with narcolepsy, okay, narcolepsy. But when her doctor certified her to return to work, the school asked her to resign. So she threatened to sue under the Americans with Disability Act. Okay, it says their response was to fire me. Paris said, I can't fathom how the Constitution would be interpreted in such a way as to deny me my civil rights as an elementary school teacher. Okay, but it says that the school did not dispute that it fired Parrish because of her threat to sue, but it maintained that part of its faith requires that such disputes be resolved only internally within the church. Okay. Are y'all seeing this? Are you hearing this? Okay. So one way to create your own jurisdiction I've always said, has been through religion. Now, one of the ways to even deal with it outside of court is to contract. And so it goes back to what we were saying, that, a minister can also, maybe speak on behalf of its members because it has contracted or has made an agreement not to speak. Or the fact that you may deal with any of your issues internally and not in the court. So it says it wanted to do that. It says on Wednesday, the Supreme Court sided with the church, okay, saying its actions were protected by the First Amendment's freedom of religion guarantee. All right. Check this. It says, writing for the court, Chief Justice John Roberts noted that since the passage of the Civil Rights Act nearly half a century ago, the lower courts have also carved out an exemption that allows ministers to be hired and fired without regard to civil rights law. Now the Supreme Court has agreed, making that position the law of the land. But on the more difficult question of determining who is and who is not a minister, the court has been equivocal, saying that would have to be determined on a case by case basis. Okay, so the argument might be that they try to say, well, is he really a minister? Does he qualify as a minister? But that's not something that the court wants to look at as a whole. They say they want to look at it on a case to case. So depending on the person in the case will determine that factor. So it says the court, however, used parish case to show how to weigh the relevant factors. It agreed that even through the bulk of parish time was spent teaching secular classes like math and science, she still qualified as a minister. The court noted that parish led her students in prayer each day, escorted her students to chapel, taught a religious class 4 times a week, and was the church designated as a called teacher, as opposed to a contract teacher. While contract teachers had the same duties, the court said, to qualify for tenure, it says parish completed ecclesiastical course, meaning religious course of study at a Lutheran college, and after passing an oral exam, she was issued a ministerial commission. So she was a minister. So as a minister, you are not even under, you are highly protected under First Amendment. You are highly under First Amendment. So yeah, you could be fired or dealt with outside of the discriminatory law, anti-bias. So, for example, I mean, if you're a minister within the temple and you're not liked by whatever reason, you could be fired. It's all religious. We create our own rules based on the rules of the church. So if you're going to go against something, you're going to have to argue within the church. But what that means is we create our own law. Okay, so that would be the issue. You see what I'm saying? So all right. So okay, so let's get back to it. So it says none of these factors will determine. So Chief Justice Roberts acknowledged both the interest of society in enforcing anti-discrimination law. It says enforcing anti-discrimination laws and the interest of religious groups in choosing who will preach their beliefs, teach their faith, and carry out their mission. The Constitution, he says, strikes the balance in parish case by requiring that the church be free to choose those who will guide its way. Then your boy Clarence Thomas filed a concurring opinion saying that the Robert's opinion was too limited for his taste. So he goes into his particular thing. But Robert's opinion for the court, however, did seem to make much of her parish ministerial commission. It says the experts were divided about just how far-reaching the court's decision is. University of Virginia law professor who represented the case, or whatever, Hassanis Tabar, saw the ruling as a home run for the church. Okay, so it's unanimous that she counts as a minister. It's unanimous that ministers can sue. It's unanimous that it doesn't matter that whether the church had a religious reason or not. The courts can't inquire into that. That's the story here today. So so you get to see how churches, how they apply in court, and how, you know, religion can be exempt by the judge. Okay. It says, what else it says? George Washington University law professor agreed, noting that the court did not require any showing by the church that its justification is real and not a pretext for discrimination. When the court says you can have no inquiry into whether this religious reason is pretextual and just a cover for some kind of discrimination, that's a big deal. Okay, a big deal. While some was disappointed, let's go. Okay, so it says still to be determined is how this all plays out in practice. Will the ruling allow religious organizations to fire ministerial employee for reporting sexual abuse to the police or for reporting health or safety violations at a church or school to civil authorities? It would appear that the answer to that question is yes. Though Roberts pointed out that churches can still be held criminally liable, unanswered though is whether a fired employee can sue for breach of contract or some other wrong. Okay, man. So I mean, I I think that's really powerful because it really states the power of the church. There is still power in the church, and that the Supreme Court, the supreme law of the land, has ruled that the church determines how they hire and fire, how they contract, and that this contract can be measured based on the First Amendment. Okay, on the religious reasons. Okay, rather it's religious or not. Okay, so today we looked at ministers. We looked at the power that minister carries under whatever religious temple or organization that he has. But we also understand that a minister can be fired by that religious organization without having to, be is exempt, basically exempt from certain laws and acts in the United States. Okay, so I think that's powerful. Please like the video, subscribe, and check out any of the other videos. We'll be posting more videos. And check me out. I'll be going live pretty much on Tuesdays and other days. But for sure, Tuesdays I'll be going live at night. So please check out the videos at that point. And until then, Tuta Nana. Peace.